Well, good morning, ladies and gentlemen, and welcome to our meeting here in One Wellington. It's been a long time since I've been in this building. I trust everyone found their way here okay. We have a one-off meeting today, and I would like to welcome to the committee the Honourable Diane Leboutillier, our new Minister of National Revenue. And of course, Madam Minister, you're here to discuss with us business arising out of a motion that was passed at the committee just before the Easter break to discuss the transfer of files from your department to the United States, according to the tax agreements and so on that we've signed as countries. And I'm looking very forward to that. The way we'll proceed, Madam Minister, is we'll have opening comments from yourself. We have 1 hour with the Minister, I believe, is what we've agreed to, and then we'll hear from the Privacy Commissioner afterwards. So we'll have time, Madam Minister, for about a 10-minute opening remarks, if that's okay, and feel free to introduce those who are assisting you at the table today, and then we'll proceed to as many questions as we can possibly get, and we thank you for making yourself available. So, Madam Minister, the floor is yours.
Merci beaucoup, Monsieur.
Thank you very much, Mr. Chair. I'm delighted to have the opportunity to speak with the committee this morning. I am here today with some senior officials from Canada Revenue Agency. There's Mr. Ted Gallivan, who is the Assistant Commissioner in the International Large Business and Investigating Branch. And we also have Marie-Claude Junot, who's a Director from the Access to Information and Privacy section. Mr. Chair, our world is an increasingly globalized one, and cross-border activities are becoming the norm. As such, tax administrators need to work together to ensure that taxpayers pay the right amount of tax to the right jurisdiction. Cooperation with other tax administrations is critical to protecting the integrity of Canada's tax system and our revenue base. In fact, Canada is part of one of the world's largest treaty networks, with no less than 92 tax treaties and 22 tax information exchange agreements in force. In 2010, the U.S. Congress passed the Foreign Account Tax Compliance Act, which is also known as FACTA. FACTA requires non-US financial institutions to enter into agreements with the Internal Revenue Service, which is the US Tax Department, better known as the IRS. This act, therefore, requires the reporting of information on accounts held by US residents and US citizens, including US citizens who are residents or citizens of Canada. If a Canadian financial institution is not compliant with FACTA, FACTA requires the US payers, that is, corporations and other entities that pay amounts such as interest or dividends, making certain payments of US source income to this financial institution, to withhold a tax equal to 30% of the payment. The 30% FACTA withholding tax can also be levied in respect of a compliant financial institution on individual account holders that do not provide documents showing that they are US residents or US citizens. And in some circumstances, FACTA could even require financial institutions to close the accounts of certain clients. In February 2014, Canada and the US signed an intergovernmental agreement, or an IGA, under the long-standing Canada-US Tax Treaty. While our countries have been exchanging tax information without any problems for decades, this agreement provides for an enhanced exchange of financial information to improve compliance with our respective laws. And the first one was in 1942. Less known is that the agreement is reciprocal. So the IRS is required to provide the CRA with enhanced information on certain accounts of Canadian residents held at US financial institutions. The intergovernmental agreement was signed in February 2014, and legislation to amend the Income Tax Act to reflect the agreement was passed by the Canadian Parliament in 2014. Canadian financial institutions that comply with the IGA and related Canadian legislation are now exempt from the 30% withholding tax. Further, Canadian financial institutions report to the CRA the financial accounts they maintain for US citizens. We, in turn, securely transmit that information to the IRS. Concerning privacy, Mr. Chair, the CRA is committed to administering this agreement and all of Canada's tax agreements in good faith. During the drafting process of the agreement with the Americans, the CRA, together with the Department of Finance, took great care to consult with the Office of the Privacy Commissioner. We received valuable input and adapted our approach accordingly as the negotiations progressed. The CRA completed a privacy impact assessment in August 2015. The goal of this assessment was to identify, to assess, and to mitigate privacy risks. Once this was done, we then submitted the assessment to the OPC for review. These commissions with the Office of the Privacy Commissioner and the resulting actions were undertaken with the specific intent of protecting taxpayer privacy. Information can be disclosed only to persons or authorities who assess, collect, administer, or enforce the taxes and tax laws to which the Convention applies. This information can be used for income tax purposes only. The intergovernmental agreement further stipulates that the information exchange is subject to strict confidentiality and other protections provided for in the Convention, including the provisions limiting the use of the information exchanged. The CRA exchanged information with the IRS on September 30, 2015. This exchange was done while the CRA followed all of the confidentiality protocols of the treaty and the IGA. Just over 3 months ago, on the 4th of January 2016, the CRA received the Office of the Privacy Commissioner's recommendations pertaining to the agreement. My officials have provided to the committee both the OPC recommendations and a copy of our response to them for your information. It is important to mention that, following our submission to the Office of the Privacy Commissioner, none of their recommendations suggested that we do not share this information. The next annual transfer of records with the IRS is scheduled for September the 30th of 2016 at the latest. I want to reassure Canadians that all tax treaties and exchanges of information are subject to strict confidentiality requirements. Mr. Chair, this is one of our priorities as a government. These information sharing agreements are very important because they allow us to better combat tax evasion and tax avoidance. Canadians are telling us that they want us to crack down on tax evasion and tax avoidance, and the government has committed to do so, as I mentioned earlier this week. This sharing of information is critical to allow us to follow through on that commitment to Canadians. In conclusion, Mr. Chair, Canada and the international community continue to move ahead towards greater tax transparency. But rest assured that confidentiality of taxpayer information remains a fundamental cornerstone of Canada's tax system. Thank you very much for your attention this morning.
Was very thorough and very well thought out and very well articulated. We now move to our questions. I don't have anybody on the list yet, so Mr. Lightbound, why don't you lead us off with 7 minutes, please?
Alors, tout d'abord, merci Madame la Ministre d'être.
Thank you, Minister, for being here with us this morning. I would like you to talk a little bit about the recommendations that you received from the Privacy Commissioner. Could you tell us a little bit about that with regard to the transfer? Answer. Well, to answer your question, I'm going to ask Ms. Junot to give you some feedback on that. Thank you, and thank you for the question. The recommendations that we received from the Commissioner deal with 3 areas. The first recommendation was about collecting information and ensuring that we only collected the information that we needed to manage that specific programme. The second was about the length of time that we could keep data for. The Commissioner wanted to ensure that we didn't store the data for longer than was necessary to manage the programme. And the third one was about providing an update of privacy issues. The Commissioner wanted us to provide information about what other programmes might use this information. And there was also a recommendation about evaluating risk. So we had to carry out a risk assessment to make sure that we included this in a risk assessment of privacy. Question. You exchanged this information before having received the Privacy Commissioner's recommendations. Did that have an impact on it? Answer. Well, it didn't have an impact on the exchange of documents. The Treasury Board directive asks us to ensure that the evaluation is completed before the transfer takes place. We completed the evaluation in August 2014 and it was sent to the Privacy Commissioner, and the first transfer took place in September. I do apologise, I said 2014, I meant 2015. It was September 2015 that the first transfer took place. Question. You spoke about the reciprocal nature of the agreement between the Canadians and the Americans. Could you tell me how many documents we receive from Americans at this level? I'm interested in this reciprocal nature because I heard something to the effect that perhaps it wasn't actually that reciprocal. Answer. This information can't be publicly communicated because it was received under a treaty, and it's the prerogative of the country that's sending the information to see whether the information can be disclosed. Thank you. That's all my questions for the moment, Mr. Chair.
On this side, Mr. Long.
Thank you, Mr. Chair, and thank you, Minister, for coming today. You gave a great presentation. My background is business, and I come from a sports background, but sharing of information is something I know is of great concern. For example, with us, with the St. John Sea Dogs, we have season tickets, season ticket base, and we always guard that base, and it's very sensitive. So do you not concede that, in the public, the perception is that there is an air of concern or a perception to the public that transfer of files is a breach? And, I live in a world where sometimes perception can be reality. So in that world, what steps is the department taking to reassure Canadians that the privacy and security is being protected? What steps is your department taking?
Monsieur Lang.
Our government takes privacy protection very seriously. All information exchanges with the US have to respect very strict confidentiality rules. The CRA makes sure that we always respect privacy rights that are enforced in Canada. when we're exchanging information, it's done so by electronic means, and there's a special, secure, efficient way of doing it. All the information received by the IRS also has to be kept secret and classified as secret, and they have their own legislation governing this. The information can only be disclosed to people working in the IRS and only for specific tax purposes, and this helps us ensure the confidentiality, and that's an absolute imperative for us. It's a priority for us, and indeed for our whole government. The privacy protection is very important to the government.
Could I ask, this is the information that was shared is what we fill out in our tax forms? Is that the information? The CRA information? Canada, what is the specific information? Where is it gathered?
Je vais passer la question à monsieur.
I'm going to ask Mr. Gullivan to answer that question.
Monsieur le Président, non. Non.
So the type of information that would be collected would be the name, the bank account number, the address, information related to deposits, income deposits, and so that's information that the financial institution collects from their American clients and transmits to the CRA, and the CRA then transmits it to the IRS. So I would describe it as financial information related to the bank accounts.
We weren't aware of this until recently, but it's been going on for some time, and that's fine. But are the financial institutions aware of the practices of the sharing of information?
Of course.
Was it a surprise to them?
Oui. Dans les institutions financières.
The financial institutions are aware of this exchange of information. What I'd also like to underscore is that had we not signed an agreement, had the CRA not signed an agreement with FACTA, the information exchange would be done via the banks. So the fact that the agency stepped in, the CRA stepped in and reached these agreements with FACTA is something that allows us to better protect privacy information and to ensure that we do have this confidentiality.
Minister, great questions. We'll now move to our next Member of Parliament to ask questions, and that would be Mr. Généreux for 7 minutes, please.
Wonderful. Thank you very much for being here, all three of you. It's great for you to take time out of your day to be here with us. And also for taking the time to debate this motion brought forward by my colleagues on this side of the table, the New Democrats. In that, I'm hoping I'm not scooping some of their lines of questioning, but perhaps I shouldn't care as much. But we'll go along this side of the table together, I guess. I have a quote here from the member he's from Nova Scotia, Sackville Preston Chescook, and he says, "We have concerns that the agreement reached with the U.S. may not stand up to a constitutional challenge, given that it forces the banks to treat clients differently based on their national origin, something forbidden by Section 15 of the Chartered Rights and Freedoms." I was hoping you might be able to comment on that, elaborate on that, seeing that that's a member of your own caucus.
Ce que je tiens à vous dire.
What I would say is that clearly we have done things different in the previous government when it came to having the agreement approved in Parliament. We did not rush it through. We did not put it in an omnibus bill. Instead, we took the time to explain clearly to Canadians and to parliamentarians the reason why this agreement was being adopted. We took the time to discuss it in a far more open and transparent fashion to make sure that people had the relevant information, the information that the population and parliamentarians need.
Explanation, Minister. However, there's views of a member of your own caucus. I'm curious as to how you being open and honest with Canadians, as you express, still doesn't address his concerns that it's stands up to a constitutional challenge. Care to comment?
Écoutez,
After having looked at all the information about FACTA, it is clear that we would have had to face this situation because FACTA is a piece of American legislation, and the decision that was taken allowed us to protect the Canadian banking system. Our decision has allowed us to protect the Canadian banking system and the Canadian citizens who also have dual nationality with the US.
And that members of your caucus are in support of this legislation when it now, I guess we'll hear more from them here, but you're satisfied that they are?
oui, je suis satisfaite de l'appui de
Yes, I'm confident of the support of my colleagues.
Want to bring up before I pass on my time. It says, we believe that the deal reached between Canada and the U.S. is insufficient to protect affected Canadians. That's also a member of your caucus, and it's attributed to the Right Honourable Prime Minister back in June 25th of 2015. Is he now satisfied that the deal previously being the same deal is now sufficient enough to protect Canadians?
L'entente suffit actuellement pour protéger.
The agreement, yes, currently protects Canadians' rights. As I said, it's in terms of the process. That's where we worked differently. We got all parliamentarians involved in the discussion. We made sure the discussion was open and transparent. We gave the information that was necessary, and that is the way that we did it, to be fair to all Canadians and parliamentarians.
Otherwise, we can move on.
I'm good. I can keep going. Yeah, and I do want to come across these. I believe these are important questions that we're asking on behalf of Canadians, on behalf of our constituents. So just want to make sure that we're putting on the record that previously a number of members of your caucus, there's a few others here which I won't go into now, and the Prime Minister were not earlier, we're not supportive of this legislation. Now, what you're indicating is that because you've had more time to review it, that you are now, the Prime Minister and members of your caucus are now supportive of this legislation. Is that a correct synopsis of your statements?
Exactement,
Exactly. And I would say once again that the problem that we had was in terms of the process that had been chosen. Had at the time all parliamentarians been involved, we would probably not even be here today discussing this. So our difficulty was at the process level.
Then question. It would allow me to question your positions then on other legislation that you may have opposed in the past. So I guess if this is an example of where we're going in the next 4 years, I would be eager to see how much of the Conservative legislation previously you do now support. With that, Mr. Chair, I am done.
Yeah, perspectives often do change when roles change, but now we'll move on to members of the NDP, and I believe Mr. Dussault is going to lead us off with questions.
Merci, Monsieur le Président.
Thank you very much, Mr. Chair. I'll be sharing my time with my colleague this morning. First of all, thank you very much to the Minister for coming along today. I'm delighted to hear you speak on this very important file. We know that there was the transfer took place in September before you became Minister, and I'm glad you're here to take responsibility for this question, even if it was something that was initiated under a different government. And I hope it'll be the same thing in other files that we're going to be discussing in the Finance Committee later on. That said, You said that you asked the Privacy Commissioner to evaluate the transfers. And that I would like to know then what pushed you, or what pushed the CRA to go ahead without having received the recommendations from the Privacy Commissioner. Answer. Well, Mr. Gullivan will be able to answer your question. The process to protect private information in Canada really is a process. The Commissioner confirmed meetings in December 2012, August 2013, January 2014. So there were a series of meetings planned, and then there were also some informal meetings that took place to prepare the document. So the document wasn't made overnight, this document that was submitted in August 2015. There was a lot of close work to make sure that information was properly protected. And then we had to look at the files that were before the court to make sure that there were no legal injunctions that would have an impact on this. I'd also refer you to the agency's long history of sharing information with the US. This is a practice that has been enforced for a very long time and has its strong roots in Canadian legislation. So we were comfortable with that. Just to continue on this point about the Privacy Commissioner's evaluation. On the 10th of February 2016, Forbes said that there were 100,000 people who were there were 700,000 files that were affected. There was a pirate access, and that this is then a problem. So I would ask, what mechanism have you got in place to make sure that this information is protected once it's transferred? Because Forbes had information that it was not being protected. Because once this information is in the hands of the Americans, what measures do you have to make sure that the standards are protected? You'll apologise, I'm going to speak in English now because I don't want to make any mistakes in what I'm saying.
Technical information technology driven document that looks at the specific IT systems, encryption protocols that are in place from an information technology perspective. And so that was conducted specific to the information we were exchanging under FATCA. In addition, there's something called the Global Forum on Information Exchange. It's a global a network over 100 countries that focuses on exchange of information and also the protection of the privacy rights of the people whose information is being exchanged. That group uses third-party evaluations. There are 3 levels of maturity in terms of protection of information, level 1, 2, 3, 3 being the best. Canada is very careful in terms of who it exchanges what information with, in terms of that grading. And those gradings are provided by independent peer review. They're quite detailed, somewhat like an OAG audit. So we feel all reasonable steps are being taken to ensure the protection of Canadians' private information.
Je vais prendre le relais.
I'm going to follow on. Thank you very much, Madam Minister, for being here. I'm delighted to be able to speak French at this meeting. I have a letter here from the 25th of June where it's written that the Liberal Party of Canada considers that the Conservative government's efforts to protect privacy did not suffice. And this is a letter that was signed by Justin Trudeau. Now, there's been no changes in the legislation since you came into power. So could you please explain to me this turnaround on the legislation that was adopted by the Conservatives? Answer. Well, as I said a little bit earlier on, it's clear that we would have done things differently when, in terms of approving the agreement. There should have been discussions in Parliament, and we would have done it. Everybody would have been involved. But what about the content? There's a tweet from Marc Garneau in July, and he says, Scott, Bryson and myself have spoken on several occasions against measures in this. So that's not just talking about the process, that's a substantive issue as well. So why are you changing position on this? Answer. The NDP clamour for measures to avoid, to stop tax avoidance. Exchanging information in this fashion is something that allows us to cross-reference information, and that can have and that allows us to avoid or to help counter international tax evasion. Are you saying to me that you're against measures that will stop us fighting against tax avoidance? Answer. I would like to have measures against tax avoidance in Canada. I'm delighted the Americans that are doing their part as well, but I would also like to talk to you about fiscal evasion and agreements with, for example, with Barbados. That would be something else we could talk about. Answer. Well, I'm here to talk about protection of privacy information today.
Mr. Boulouris, your time has come close to its end. I don't think there's enough time to ask another question. We'll now move to Mr. Erskine Smith, please.
First, thank you, Minister. Second, I do want to shift gears a bit, but I want to stick to access to information, the mandate of this committee. Specifically, I want to turn to the work of Percy Downs, Senator Percy Downs. I commend him for his work bringing attention to the tax gap. That's the difference between what the CRA is owed and what it actually collects. In other words, how much is lost to tax evasion. And my question relates to a previous dispute as between the CRA and the Parliamentary Budget Office. Has that dispute been resolved? Has the CRA agreed to provide the Parliamentary Budget Office the documents that it's requested?
No? Okay. It's not technically relevant to the study that to the motion that's before us. However, Madam Minister, if you're comfortable providing an answer, we can proceed this way.
And the answer could be in writing to me later, but it is relevant to this committee. It is an access to information issue, I think, for Canadians to know the tax gap.
Yeah, certainly, but we do have a very focused motion here, and I would appreciate it if we could keep on that track. I'll allow members certain latitudes when it comes to asking questions, because these are parliamentary privileges that we all have. Madam Minister, if you feel free to answer if you wish, but if you're not comfortable, you don't have to.
Non, écoutez,
Well, we made an important announcement on Monday talking about the money that was going to be invested, the $444 million that were going to be invested. And our position was supported, and so we are working closely with the Senator, and he supported our position, and yes, we can get this information.
It's your only question?
That was my only question. Well, I mean, that's my only question.
All right, Mr. Saini, did you have some comments?
Oui. Ministre, merci d'avoir pris le temps d'être.
Minister, thank you very much for having taken the time to be with us here this morning.
You could just maybe highlight the main points in the Canada-U.S. intergovernmental agreement, and also if you can confirm whether there's any Patriot Act implications with this tax treaty that we have.
okay. Je demandais à M. Gallivan de...
I'm going to ask Mr. Gullivan to answer your question.
Agreement, the exclusion of RRSP, RE, TFSAs, and those kinds of accounts from the exchange. I think limiting certain small deposit-only institutions were important narrowing of the scope of the exchange. And so I think also the kind of the mechanics of the exchange in terms of the timing when the CRA would receive the information from the banks, the scope of the information we would receive were important aspects of the exchange itself. And the second part of your question, could you just...
was whether there were any Patriot Act implications.
Right. So the intergovernmental agreement with the U.S. confirms that the information would only be used for tax administration purposes. So any use under the Patriot Act would be a breach of the agreement the U.S. signed with us.
So you're confident that any tax information that's conveyed to the United States would only be used in that specific area, would not be shared against or shared with other U.S. departmental agencies?
The U.S. government agreed not to, and we have a long history of exchanging significant volumes of information with the U.S. government, and so I have no reason to doubt their word.
The second question I have is, you mentioned, Madam Minister, in your opening remarks that the next release of information will be on September 30th, 2016. Is there a reason why that date was specifically chosen? Is it because of the U.S. fiscal year end, or is there just an arbitrary date that was assigned? Just for my own interest.
Est-ce que c'est vous? Madame Non, moi je...
I don't have the answer to that question. I would have to take note of your question and get back to you. I'm not sure if there's a specific regulation that governs that. I'm not sure.
That for some reason or some purpose, but I'm sure the answer can be found to your question and submitted to the committee. I'm sorry, I didn't mean to cut you off, Madam Minister.
I mean, just quickly in terms of context, what's being exchanged is data on the preceding tax year. So in other words, in 2015, we shared tax data relating to 2014. So the delay to September is to allow people to file their tax returns, to get it into the system, to get it cleaned up. And so the banks as well need time, and that was part of our work with the Canadian financial institutions to minimize the burden on those businesses. So if we're asking for information about a year, I guess we're leaving time for the banks to clean up their data, get it to us to make sure that it's protected and off to the Americans. But we can get back with a more specific answer on the date.
Certainly. Okay, well, that ends our first round of questions, and I'm sensing that the momentum around the table to ask more questions is fading unless others have some questions. Mr. Bertina?
Thank you. With regard to the Act, what does it say about breach? What would happen in the case of a breach of the agreement, either side? Is that stated clearly in the document?
What kind of breach by the financial institutions?
Yeah,
or by
some of the
US?
information gets out there. A breach of this agreement.
What I would say, in the past, Canada has had a treaty partner breach an agreement, and we cut off all future exchanges with that jurisdiction. And so I think in the global community, when a jurisdiction has that kind of serious breach, other jurisdictions respond by ceasing to exchange information until they're satisfied that that government has put in place the necessary controls.
And would the aggrieved party likely seek compensation through the courts? Like, would this be something you would envision that someone would sue someone because this information had gotten out? It's a hypothetical situation, but we have a lot of agreements. The agreements with other countries. We have the agreement with Saudi Arabia where the government is required to follow through, and hopefully there would be not a breach of the Act. So I'm just curious about what the remedies are or what the circumstances would be in case of a breach.
Okay. Ce que j'aimerais souligner,
What I would like to underscore is that FATCA is an American act. There are more than 100 countries that have to be in compliance with this legislation in terms of American citizens who have double nationality. Doesn't matter where they're living in the world. In terms of constitutionality, all agreements are checked by the Justice Department before they're adopted.
Going back with another issue, which is the Investment Canada Act, and an occasion where we have information, they have information, we'll share it, but they don't want to. And so the pressure on the government is to release information that is considered confidential. So I gather from what you're telling me that it's a serious business to breach an agreement like this, at either side.
From a tax authority perspective, exchange of information is becoming increasingly important. and reciprocity is increasingly important. And so at the G20 level, direction is being given to work coordinated by the OECD for jurisdictions to share information. The most recent budget talked about country-by-country reporting for multinational corporations. You would have certainly seen the coverage of the Panama Papers, where the CRA has engaged its treaty network with other jurisdictions to share information. But for those global networks to work, everybody has to play by the rules. And so as a tax administrator, I take Canada's role very seriously, as do my colleagues in other countries. And it's by all of us respecting our legislation that we can make the regime work globally, because we're faced with kind of global tax concerns. And so back to the question of what is there a breach, the most serious consequence for a tax administration perspective would be our ability to apply the law. And so I think, a question of a lawsuit isn't the tax authority question. The tax authority question, we would be cut off globally from sources of information, which would be very damaging to our ability to operate.
Thanks very much.
Okay, thank you very much. That we did move into the second round of 5 minutes, so that kind of takes care of, I got it out of order. I should have gone over here first, but that's my fault. That's on me. So we'll go now to Mr. Kelly.
Okay, thank you, Mr. Chair. Under the intergovernmental agreement, Canadian institutions, have any Canadian institutions failed to comply with the IGA to date and been subject to the 30% withholding tax under FACTA? There have been instances where there have been failings to comply.
Non, pas pour l'instant.
No?
Thus far, no.
Information which is not subject to the agreement, such as Canadian-held RRSPs, TFSAs, or whatnot, being disclosed to the IRS? Not aware of breaches of that nature?
Pardon? Oui.
I'm not aware of any breaches. What I'd underscore is the Canadian financial institutions have done a lot of work to administer this in an effective manner. And so what is happening is these institutions are reaching out to the CRA for clarification before the mistake happens. They have done a tremendous amount of work to make sure this regime works. And so what we have had are a lot of calls from financial institutions making sure they don't make a mistake. So the Canadian financial sector is very focused on not making an error in administering this law.
Well, I certainly don't doubt their eagerness to comply and the diligence with which they would and priority that they would put on compliance. But given the millions of potential files out there and pieces of information, it's surprising that one could say with that sort of degree of certainty that such mistakes and such breaches don't happen. I mean, institutions have, under Canadian law, have tremendous responsibilities to protect their clients' information, and it would be surprising that there would be, these two conflicting forces on an institution that breaches don't occur, and so I think we have to be always concerned that information isn't improperly handed over. I don't have much more for questions, Mr. Chair. If you had one you wanted to jump in with, or
certainly, if you don't mind, if that's okay with colleagues, I do have, other than myself, Mr. Boulouris and Mr. Dussault, I'm the only member of Parliament at the table that was actually here when these debates were happening in the last Parliament, and I'm not going to ask political questions. In my capacity as chair, I'm going to be as neutral as I can, but if you'll allow me, Madam Minister, if I've got this right, and my recollection of this was the change in the U.S. government's administration and, of course, their legislative compliance that would, with their legislation that we come into an agreement. We've had a long-standing tax treaty with the United States government, but it was about 4 or 5 years ago that they started to actively enforce their tax policy, whereas before they didn't actively enforce their tax policy. and the tax policy is that the United States of America taxes citizenship, not residency, which is a difference between Canadian tax policy and United States tax policy. Would you agree with my statement or my assessment? So in coming to compliance, of course, the Government of Canada of the day had to enter into an agreement, as you've aptly pointed out, in order to protect Canadians. Otherwise, the banking institutions or financial institutions in Canada would be directly dealing with the U.S. government, and there would be no government intervention to provide that bottleneck for the purposes of protecting Canadians' information had the Canada Revenue Agency not stepped in. While you and I may disagree on whether or not the process was done in a way that it should have been done, we both agree at this table, it would seem like, that the result that was needed was actually done, because the current government seems to be okay with the legislation and the changes that were made with the previous government, and I'm not here to debate that with you. But I remember in the past government, and during the debates in the House of Commons, one of the arguments put forward was that Canada fared very well in its agreement to come into compliance with the United States change in policy compared to how other countries fared in their negotiations with the United States. And I'm just would like some clarification from you, Madam Minister, if you think that still holds true.
As I said a little earlier, the agreement with FATCA is something that had to be done in Canada. We had to sign agreements with the US. The difficulty really that we had really was in the process within the House of Commons, the way it was handled. There ought to have been open and transparent discussions with all parliamentarians.
Was though, and it's okay if you don't have an opinion on this, that's fine. I'm asking for an opinion from yourself, or if I can have a technical opinion, if you're comfortable with your staff answering the question. I'm looking for some clarification. Did Canada fare very well in its updating of the tax agreement relative? You yourself said, Madam Minister, there was over 100 other countries that had to come into compliance. Did Canada fare relatively well compared to those other countries when it comes to our protection of privacy and the nature of the agreement?
The answer is yes. In terms of the limiting the scope, for example, TFSAs, RRESPs, the smaller financial institutions that may not have the capacity, having them excluded, those are important. I can assure the committee that senior level intervention, one level below the commissioner, was necessary to wrest these compromises from the Americans. At more junior levels, they weren't as willing to compromise, and so I do feel Canada got an agreement that works for Canada.
Thank you very much. I appreciate that answer. We can go now to Mr. Lightbound for a few minutes. We've got the Minister for about 10 more minutes, then Mr. Dussault, and that will finish off our rounds of questions.
Oui, je vois, je pense que c'est un petit peu dans la même ligne.
Following on from what my colleague was saying, in some countries the banks transfer the money directly to the IRS or do the transfers directly. What filters are there in Canada for doing this this transfer? When a bank decides to transfer some information to the Americans, does that go through, or is sometimes it withheld? How does it? What sort of filters are there in place? I'll pass the question to my colleague. We have a formula, a sort of filter that says what's acceptable, and if the action isn't in compliance with that, with the definition, then it's not done. We monitor all the financial institutions. We make sure that we know which institution we're dealing with. We want to make sure we know which one we're receiving the information. But we don't verify, for example, the business number or insurance numbers. The information is given to the Americans as it is, and our job, if you want, is to protect the whole envelope rather than looking in the envelope and looking what exactly has been sent. Question: are there risks for a Canadian citizen who has no connection to the States getting caught up in this system? Answer. We believe that we have the necessary controls in place. That's why we worked with the Office of the Privacy Commissioner. That's the reason that we also set up a feedback process with the banks. It's difficult for me to say it would be absolutely impossible for that to happen, but as the Minister was explaining, is that the agency's worked extremely hard to do its best to ensure that it won't happen, and we also have measures in place to correct things straight away if there is any error, and that is what the agency does in the process. Question. There's a certain room for manoeuvre. The agency could, perhaps say that there were perhaps some shortcomings that needed to be addressed, but perhaps I should ask another question instead. I know that at the time the banks were saying that this agreement with was essential, but what would this? They needed it because of the 30% that would be taken. How much money is that worth? How much were we talking about when we say the 30% that would have been withheld? I don't have the figures. Perhaps my colleague would like to add something. Yes, it's not. The banks weren't just concerned about the money itself. They were also worried about the administrative burden of having to withhold this. Yes, there's the question of the money, but there was also all the work that was involved in withholding it.
Mr. Gallivan, I'll direct this question to you. In the Minister's opening remarks, she said that there were 92 tax treaties and 22 other tax information agreements in force around the world. So my worry is that because we have a robust system of information and declaration, when you're dealing bilaterally with other countries and they're asking us for tax information within these agreements, I'm very confident that the information that we would provide would be, second to none. My worry is when the CRA asks another country for bilateral information, what guarantee do we have that the information that they're providing us meets the same standards when we convey that information to them? Do we have a standard sort of system where the information going is probably standard, but the information being received amongst other tax regimes, how do we assess that the information that we're getting is clear and transparent?
I think the best way to answer your question is we don't just take that information and issue a notice of assessment to the taxpayer. So the kind of information we're talking about is what we use in something called risk assessment. So we're getting a list of people's names and we're saying, aha, maybe we should take a second look at these people. Often what happens in tax authorities is those lists are compared to other lists and we look for inconsistencies. In other words, significant bank accounts, very low income. Well, that puts you on a list for closer review. We'll do closer review of the information to actually confirm what's going on. So I think the assurance I could give you is we don't blindly take that information and change people's tax returns, but it's one ingredient in helping us decide who to take a closer look at, and then we would work with that taxpayer to kind of confirm the information.
Inconsistency?
We've already gone over the 5 minutes. I hate to be a stickler. I was looking for people to take up time earlier, and now I have to cut people off. Mr. Dussault, for up to 3 minutes, please.
Merci, Monsieur le Président.
Thank you. And once again, I'll be sharing my time with my colleague. A brief question, Minister. Do you think that it would be reasonable to inform and to warn Canadians who have a double nationality that their information is being transferred? Do you think we ought to give them a copy of the information that's been transferred to the States? Do you think that would be a good idea, a good road to go down? Madam Minister, do you think that's a good idea? Answer, to give them all of the information? Well, in the agreement that we have, people who want to have information, who want to know what was transferred, they can get in touch with the agency and their financial institutions, and they'll be given the information. Question, do you think it ought to be done automatically? Answer, in terms of the CRA. We have a group that is dedicated to this issue. Question, do you not think it ought to be automatic? As soon as the Government of Canada gives information about you, that you ought to be informed of it? Answer, if there are any changes to be made in terms of the agreement, we'd have to refer you to the Department of Finance. I'm asking if you think it would be a good idea. Answer, it was Finance that negotiated the agreement. If you want to see changes, that would have something to be negotiated with Finance. Do you not have an opinion on this? I would have to reiterate my answer. This is something that is under Finance. Revenue, the CRA applies the agreements, but the agreements themselves are negotiated by the Department of Finance. Question. You said that there are very strict measures in place to protect Canadians' privacy. Could you explain the news on iPolitics this morning that TD sent a letter to parents to say that their daughter's bank account was going to be, there's a little girl who was 8 months old, that her information in her account was going to be sent to the US? How can that be? Is that strict privacy protection measures? Answer, well, I think you're talking about a financial institution that got in touch with a client to confirm the nationality of the client. I think it's perfectly normal that a banking institution is in communication with their clients. Later on in the article, I think it was talking about RESPs, and remember that the agreement with the US excludes RESPs. And this is something that this is one of the exclusions that we managed to negotiate with the states.
Gentlemen, for your questions. When we came through the rounds, we're almost there, Minister. I hope you can stay. We got about 3 minutes left, and I owe the Conservatives 4 minutes, and I owe the Liberals a minute and a half. So how do you guys want to do this? One question here, one question here. Is that okay? Here, take the. Okay, we'll go over here. It's very generous.
Thank you. And Minister, yes, almost done. A few more minutes left here. Sorry, just want to bring one additional example to the table. In 2012, the honourable member from Bourassa, who's joined us here today, and also your parliamentary secretary, mentioned, and again in 2012, that he'd vigorously fight against a similar change. So, again, for the record, we have the Minister of Transport, we have the Treasury Board President, we have yourself to an extent, we have a member from Nova Scotia, we have the Parliamentary Secretary, and we have the Right Honourable Prime Minister, who have said that this is something that they do not want, they do not want to support. However, in October 19th, 2015, have a complete reversal of opinion on it, and again, just to be clear, that your position is now it's because you have had a chance to read through the legislation in more detail than you've had before, and that's why this reversal of which seems to be opinions that have been long held, going back to 2012 now, have reversed opinion. Again, Minister, if you could just clarify for me one more time, this is the position that you take.
As I said earlier on, had our government been in power at the time, we would have taken the time to explain clearly to Canadians and to parliamentarians the reasons why we were adopting this agreement, and we would have taken the time to discuss it in an open and transparent fashion. Our difficulty really was in terms of the process, and to see this agreement being rushed through in an omnibus bill that was more than 400 pages long.
The answer to my last question, word for word almost, but is that my time, Mr. Chair?
That's
Okay.
your time.
All right. Thank
We
you.
have time for one more question, even though we're kind of creeping on. Mr. Saini, I wanted to make sure I got back to you so you could finish.
Thank you very much, Mr. Chair. Just a quick question. It's another arbitrary question, but my interest is that when the United States under FATCA asks a Canadian institution about a particular bank account, is there a threshold? Because if they're asking about, it can go from 0 to whatever. Is there a certain threshold? Because you talked about the administrative burden for banks. So I'm just wondering what the burden is in terms of administration as to what level they're seeking and whether you believe that's an appropriate level.
There is an administrative threshold of 50,000 that would represent 50,000 Canadian dollars in aggregate, I believe, from all accounts, checking, savings, and if somebody were below that threshold, the bank would have the option not to transmit the information.
Is there some guidelines as to what those reasons would be? Or is it just the sort of request from the U.S. government? So it's an arbitrary sort of...
The threshold that I'm familiar with is 50,000.
Below that, though, if there's questions below that, are there particular points that have to be requested, or is that just?
I'm not sure I have an answer to the question. We'll take it back and
Sure.
try to get you a written response.
Thank you very much. Thank you very much, Mr. Saini. Thank you, Madam Minister and Madam Junot and Mr. Gallivan for coming. I want to correct something. I made an incomplete statement earlier when I identified just myself and Mr. Boulouris and Mr. Dussault being here from a previous parliament. Mr. Dubourg was also here in the previous parliament, and I failed to recognize that in that comment. I wanted to be clear. We thank you very much for your time and your answers. It was very helpful, I think, not only to us around this table, but for Canadians who would be watching this at home. Thank you. We're going to suspend for a moment, and then we'll hear the Privacy Commissioner's opinions on this matter. Thank you very much. So we are now resuming, colleagues. If I could have a little order at the table. If I could have a little order at the table. If I could have a little order at the table. We're now resuming. We are continuing on with the motion that was passed a couple of weeks ago to examine the transfer of information and the tax agreements between Canada and the United States. We just heard from the Minister, and now we're very pleased to have Mr. Therrien here, the Privacy Commissioner. Commissioner, if you would like to open with a statement, and we'll proceed to a round of questions, as I'm sure you're all too familiar with, and we thank you for being here today, sir.
Messieurs les membres et Madame les membres.
Members of the committee, thank you for having invited me to provide my views on certain aspects of the Tax Information Exchange Agreement between the CRA and the US, in particular the IRS. Madam Minister explained the legal framework under which the transfer takes place, so I'm not going to repeat what she said. I would just remind you that there are two important documents. Firstly, there's an agreement between the two governments, that's an IGA, an intergovernmental agreement, and then there are the provisions in the taxation legislation that were introduced in 2014. Under the IGA, the Canadian government has undertaken to gather certain information held by financial institutions and to transfer them to the US. There are two steps to this process. Firstly, the Taxation Act explains in which cases the Canadian institutions have to transfer the information, and the CRA then will communicate this information to the IRS. The intergovernmental agreement is reciprocal, and the CRA also receives information from the CRA. In previous appearances before Parliament on FACTA, my office recognised the long-established practice of sharing information for tax purposes between two countries. For example, we have the Convention between Canada and the United States of America with respect to taxes on income and on capital, which lays the foundation to exchange information under the IGE, and that was signed in 1918. In more recent years, there have been international efforts undertaken by the OECD for the automatic exchange of tax information. We also, however, conveyed our expectations that information sharing activities be undertaken in a way which respects privacy rights of individuals. And this is something that holds true both for the CRA and for the financial institutions. As we said in our appearance on Bill C-31, as well, which amends the tax legislation, as well as in our review of the privacy impact assessment submitted to us by the CRA, we expect there to be limits to the collection, use and disclosure of personal information. We expect there to be defined retention periods, and also that there be appropriate safeguards in place to ensure that the information is protected. For example, all parties involved must limit the collection of personal information to what is necessary and not collect data elements that are not required. This applies not only to the CRA, but also to reporting institutions governed by the private sector legislation, which is, of course, the PIPEDA. Similarly, use and disclosure of personal information must likewise be limited. The IGA specifically notes that information received under the IGA is subject to protections provided for under the Convention between Canada and the United States of America with respect to taxes on income on capital, which limit use and disclosure to only the collection, administration and enforcement of taxes. With respect to retention, as we understand it, the CRA retains its records for 7 years, which is consistent with the CRA's retention of individual returns. With regard to safeguards, we note that the IGA states that exchanges are subject to confidentiality and to protections under the Convention between Canada and the United States of America with respect to taxes on income and capital. The Convention mentions that information received shall be treated as secret in the same manner as information obtained under the taxation laws of that state. The CRA is expected to protect personal information from unauthorised uses and disclosures of personal information, especially considering the sensitivity of financial information and the reasonable expectation of individuals that it generally be kept confidential.
Assessment from the CRA in August 2015, and we are pleased that the CRA has adopted all of our recommendations, including 1, reducing its retention period from 11 to 7 years. 2nd, educating financial reporting institutions to guard against the risk of over-collection. 3, committing to safeguard information, including through specific measures to mitigate risks identified through its threat risk assessment. And 4, updating the privacy impact assessment to reflect all proposed uses and disclosures of personal information, and ensuring that these be strictly limited for purposes of tax administration only. While my office acknowledges the need to combat tax evasion, it is important for the enabling legislation to be clear in the obligations it imposes on all reporting entities, including the CRA and organizations that have FATCA reporting obligations, such as financial institutions. For example, the IGA states that unless a reporting institution elects otherwise, accounts under certain thresholds, such as deposit accounts under $50,000 US, I believe, although perhaps Canadian, are not required to be reviewed, identified, or reported. However, Part 18 of the Income Tax Act seems to require reporting on all U.S. reportable accounts unless the financial institution specifically designates an account to not be a U.S. reportable account. So this leads to a concern. The concern is that given the apparent discretionary nature of the threshold exemptions, it may not be clear when accounts under $50,000 will be reported to the CRA. My office has written to the CRA with follow-up questions following their response to our earlier comments of December 2015, including how many accounts under US $50,000 they have received and transferred, clarification on how threshold exemptions are applied, clarification with regard to the level of review the CRA performs on records that are transferred to the IRS, and if the CRA could advise how many records it received related to Canadian persons from the IRS. We've also requested clarification as to why the first round of records sent to the IRS were more than originally estimated. In conclusion, FATCA reporting requirements are an example of cooperation between states on tax enforcement, and in that respect, it is neither unusual nor objectionable. That said, privacy principles have to be respected and provide balance in the implementation of the arrangement. The IGA and implementing legislation create legal effects vis-à-vis privacy law by creating an obligation to share without the consent of the individual under the Privacy Act or PIPEDA, the private sector legislation. There is also some lack of clarity around questions on reporting threshold exemptions. To this extent, we are again following up with the CRA. We've written to them earlier this week on these issues as part of our PIA review process. Protecting the privacy rights of individuals and advising on improving protections under information sharing agreements are key parts of my mandate. Given that Parliament has chosen to pass implementing legislation to support FATCA reporting requirements, we continue to strongly recommend that these obligations not to be over broadly applied, but appropriately balanced against privacy rights. I'll be glad to take your questions.
Thank you very much, Mr. Commissioner. Some interesting points that you brought up, and I'm sure we'll have some interesting discussion. We'll now we'll move to the Liberals. Mr. Saini, for up to 7 minutes, please.
Thank you, Mr. Commissioner, for appearing here again. We really appreciate your input in our discussions. I just want to go back to a point that I'd asked the previous witness regarding the $50,000 amount. And what concerns me about the amount is not necessarily the amount, but the discretionary nature in which something information can be parlayed to another entity. Do you believe, in your opinion, that there should be strict criteria? You know, if $50,000 is the threshold and that's what's been agreed to, then anything above $50,000 can be parlayed according to the Act. But anything below that, to me, suggests that there should be something in the Act that states or stipulates that these are the certain criteria specifically that should be in place before that kind of information is parlayed. In your opinion, is that something that we should look at?
The short answer is yes. So I would start from you start from the fact that agreements between states to avoid tax evasion are obviously desirable and necessary. So a certain amount of information will have to be shared between states to prevent tax evasion. But what type of information, what criteria, how clear are the criteria for sharing of information, what measures should be taken to guard against privacy breaches, all of these are the privacy conditions under which what is a reasonable agreement in principle would properly balance tax information purposes and privacy purposes. And here on the question of the threshold, so that's presumably an accommodation that Canada was able to negotiate with the U.S. government in terms of exemptions to reporting. So the threshold of $50,000 exists, but point one, it's not clear how it's applied. There seems to be a discrepancy between the agreement, the IGA, which according to our reading appears to say accounts under $50,000 need not be transferred, while the Income Tax Act, the federal Canadian Income Tax Act, seems to provide all accounts are provided except as determined by the reporting institutions. So this question of how firm is the $50,000 threshold, how it's applied, is not clear, and that leads to ambiguity and the risk of over-reporting of information.
The second question I have, and it's a similar question that I asked to the previous witness, was the fact that Canada has, according to the Minister, 96 tax agreements around the world. So my worry always is that when someone asks us for information, we have a robust regime of making sure that their information is privately maintained or will not be disseminated widely. What guarantee do we have when we're dealing with other tax regimes in other countries whose privacy issues may not be robust as ours? Do we have some sort of mechanism where we can measure that Canadian information that's being sent somewhere else around the world, do we have some sort of genuine confidence that that information cannot be disseminated, or how do we determine that? Or are there gaps that we have?
From other states as opposed to sent to other states?
Sent to other states.
Well, under this arrangement, the information that is sent to another state is sent to the U.S. There may be other arrangements where Canada sends tax information to other states in order to gain reciprocity. So in terms of the information sent to other states, the guarantees are the guarantees that would be offered by the CRA, I would assume. In terms of the adequacy of the information received by Canada from other states, the official from the CRA told you that this information is then checked to determine whether or not, and the answer may be not a tax assessment against the Canadian. But this type of question, what kind of information does the CRA receive in return from the U.S. or, in your case, potentially from other states? That's a question we've actually asked of the CRA. What kind of information do you receive? Is there over-collection of information in relation to tax agreements that Canada may have either with the U.S. or other states? So we don't have that information at this point, but it's a question we have asked of the CRA. What measures do you take to ensure that the information you receive in return from other states is not over-collection?
You still have a couple minutes, sir.
Just one final question. What obligations, if any, do other countries, like the example, the United States, UK, have when it comes to protecting foreign data, and how are these obligations created, monitored, do we have some sort of comparison with other countries in terms of what our regime is like?
There are no formal international rules on these questions. All institutions, public and private, have an interest, and to the extent that there is legislation in these countries and in the countries you've mentioned, there are legal requirements to protect information. So it's a question of what is the legal regime in place. In the UK and the US, there are provisions that require institutions to protect information properly. And it certainly could be part of an agreement between Canada and another state to ensure that once the data is sent to the other state, that it is properly safeguarded. But it's either a question of national laws or potentially the content of an agreement reached between Canada and another state.
There's still about a minute left. Mr. Bertina, quickly, please.
Can I ask, on the follow-up, your office has written to the CRA, including how many accounts under USD 50,000, and requested clarification as to why the first rounds were more than originally estimated. So have you received the information yet? When did you ask for the information, and are you still?
So the sequence in the correspondence was that the CRA sent us their privacy impact assessment in August of 2015. We responded in December. They have adjusted their rules about 2 weeks ago, and since we have received that letter 2 weeks ago, we wrote earlier this week to ask these questions. So among the questions are clarification around accounts below $50,000, but also the other point you're mentioning, when we were having discussions with the CRA earlier on their estimate of how many accounts would be sent by Canada to the US under this regime, the estimate of the CRA was slightly under 100,000 records, and the number of records actually transferred was more in the order of 150,000. So we have no way of knowing what are the reasons for this, whether they're accurate, legitimate, incorrect. So among the questions of clarification that we've sought is, please explain why your estimate did not turn out to be true. Is it because simply you were underestimating, or are there other reasons to explain the difference between your estimate and what actually happened in practice?
Especially in the order of numbers from under 100.
Yeah.
So we're well over the time now, so we'll have a chance to follow up, Mr. Bertina, I'm sure. Mr. Kelly, for up to 7 minutes, please.
Thank you again for coming to our committee once more. You mentioned that you expect there to be limits on the collection of use, retention of personal information, that all parties must limit collection of personal information to what is necessary. Do you have examples, or can you provide some examples of personal information that might be collected for tax purposes which you do not consider necessary to be collected and would like to see excluded from information sharing agreements?
Example would be these accounts under $50,000. So again, you start from the principle that it is legitimate for the two states, Canada and the US, to share information to avoid tax evasion. And in order for Canada to obtain information from the United States, we have to provide some information to the United States in terms of this reciprocity. The purpose of the whole scheme is to ensure that the tax regime of both Canada and the US is applied properly. Yet, the arrangement provides for certain exceptions. You've heard tax officials refer to some of them having to do with TSFAs and so on and so forth. So even though the rule is exchange of information for tax purposes, the arrangement provides for certain exemptions, including this question of whether accounts under $50,000 should be reported or not. So the rule should be clear. What happens to records under $50,000? And if the rule is that they should not be reported, then that would be an example of information that theoretically would be relevant to a tax assessment that should not and would not be necessary to be transferred because the arrangement provides.
With respect to retention periods for information, do you have any suggestion on how how to require these or any other aspects of our agreement to be enforced, other than I mean, we heard from the minister that ceasing the reciprocity of our agreements is the one threat that we have. Are there other means, though, other than that, to ensure or to require or enforce respect for retention periods, for example, from the IRS with information that's been shared under the agreement?
From a privacy perspective, the retention issue relates to, again, the ultimate purpose of the arrangement, which is to avoid tax evasion. So the two governments share information for that purpose and should only retain that information for a period which is necessary for the other government to actually take a tax enforcement action. Normally in Canada, the information is retained for 7 years. Originally, the information shared between Canada and the U.S. was retained for 11 years, and we've actually asked the CRA to justify that period, and they have agreed in their response to our comments of December to reduce the period from 11 to 7 years. So we think 7 years is a reasonable period.
Okay. My question was more about ensuring the reciprocity of this, and what means, or do we take any steps to verify or assure ourselves that the IRS respects our notion of an acceptable retention period, and that they in fact destroy or otherwise not have use of information that exceeds what we would consider to be appropriate retention and use of the information?
So I don't believe we have asked for clarifications along those lines yet, but they are certainly relevant, and so we will check on the content of the IGA, and if the agreement does not speak to this, we will ask these questions of the CRA.
Okay. What remedies or recourse does a Canadian whose information has been shared with the IRS under the IGA have if the IRS breaches their privacy through improper disclosure? Are there any remedies or recourse available to Canadians?
I would start with what recourses would there be for improper disclosure, say, either by Canadian institutions or the CRA. So Canadian financial institutions normally would have to keep the information of their clients secret, but the arrangement provides the legal basis for them to share information with the CRA with a view to sharing it with the IRS. So PIPEDA, if there is something wrong and if there's over sharing of information, PIPEDA would be a ground to invoke, and in terms of oversharing by the CRA to the IRS, the Privacy Act could be invoked. Now, if on the American side there is something untoward that is happening, again, we will have to look into this question.
In July 2015, there were reports of a cyber attack on the United States government, computers which contained records of some 20 million current and former holders of United States security clearances, as well as their friends and family, which was a disturbingly large breach of privacy in the United States. Can you comment on whether any Canadians had their privacy breached in this incident, and what recourse, where I guess perhaps you've answered that question, that we're not sure what recourse a Canadian would have under American law, but under Canadian law, perhaps. Is this an area where the IGA and other information sharing agreements address security of information adequately?
We have asked along those lines is for the CRA to give us information about the threat assessment or the risk assessment, the risk of breach assessment that they are conducting. And that will be, we have not received that information yet, that will be part of the next round of information that the CRA has promised to give us by the fall of 2016.
Okay. So we don't know yet. Okay.
Yeah, that's 7 minutes, Mr. Kelly. We are now moving on to another 7-minute period. We'll start with Mr. Dussault.
Thank you, Mr. Chair. And thank you to the Commissioner, Mr. Terrien, for being here with us this morning to discuss this important question. As I said earlier to the Minister, what started this off for us was that your evaluation came along after the information had been transferred. I'll ask the same question to you then. As I asked the Minister, do you think that that is acceptable for an agency to ask for your opinion and to ask for your recommendations, but without even waiting to have the answer, goes ahead and makes a transfer? Answer. I'll make some general comments, and then I'll talk about specific cases about this information being exchanged with the CRA. Mr. Galvin answered earlier. He said that there were, as well as correspondence, there were a number of meetings that were held between our office and the CRA before that the evaluation was officially done, and that is true. There were 2 or 3 meetings before we started exchanging correspondence. Treasury Board's policy requires, as he said, or does not require, that the Commission gives its approval or its answer before a new programme can be set up. So the CRA was in compliance with the policy in acting in the way that it did. There were a number of meetings that were held. There was an exchange of correspondence. And 3 months after that exchange of correspondence, we gave our opinion. So the policy was respected. In general terms, you're asking me, is this something that's desirable? No, I'd say it's not a desirable situation. I don't think it's necessarily desirable that departments can introduce new programs without having had the formal opinion of the Privacy Commissioner's office on this. But that is the regime that we have in place at the moment. As members of this committee are aware, our office made a number of recommendations to amend legislation, and amongst the recommendations that we made, you will see that there's one where we suggest that it be a statutory obligation to have a privacy evaluation, not just a policy evaluation, and that would allow us, and ideally we've recommended that the recommendation from the Commissioner's office be taken into consideration before the new programme be implemented. Thank you, that was a very interesting answer. During the process that you discuss, did you get any files, some of the files, or information about the 150,000 files? Or did you simply have to rely on the CRA to tell you what was actually happening with these 150 files that are issued? Did you see them? Answer. If we had reason to believe that the regime was not being applied properly, then I am entitled to carry out a verification, but we're not at that stage. I'll come back with some further questions later. I'm going to let my colleague speak now. Thank you very much, Mr. Terrien, for being here with us this morning. My colleague asked a question earlier that I thought to be an interesting one. He spoke about the limit of collecting information. That's something that you touched on in your presentation as well. For example, accounts that have less than $50,000 can be excluded under an exemption. Do you have any examples of information that ought not to be shared because of privacy concerns? And not just, I'm not exemptions that shouldn't just be there because of the amount of money. Answer. The Privacy Act allows information to be exchanged for all purposes under the IGA. Once again, let's think about the objective of this act. It's to avoid tax evasion. So that is the overall purpose of it. This is the information that can be exchanged. The fact that there is an agreement means that the exchanging this information is acceptable. I gave you the example of the accounts under $50,000 because it's not clear, the situation. There's some doubt there. But to go back to an earlier discussion we had in the department, in terms of whether information can be exchanged to make sure that there's no tax evasion, you have to also make sure that you're not sending in more information than is allowed by the agreement. So it's fine to have the exchange of information, but you're not having to, you shouldn't be sending more than you actually need for that purpose. And we still don't have a precise answer to that. Question. My question then would be, how can you actually check that? How can you verify that? You're saying, well, we were asking these questions, but we don't have a clear answer. We haven't asked this question as such yet, but this is the question we're getting to because we see that this is important, and we will wait and get an answer from the CRA, and we'll see if it's a satisfactory answer. If we don't feel that it's satisfactory, the answer that we're given by the CRA, at that time we can go in and verify things.
About a half a minute left, but I thank you for your good use of time. Mr. Bertina is going to start us off
So
now.
coming back to the questions that you had for CRA and so on, we had the Swedish ambassador discussing under access of information in Sweden that the generally accepted response time is today. Now, I understand that the questions that you've asked don't involve data on a piece of paper that you just hand the paper over. Someone's got to think through this. But what would you anticipate? Because I'm thinking of the public, Mr. Chair, trying to get access to information. We have the Privacy Commissioner trying to access information. So I'm just curious to know what you would anticipate would be a timely response to your inquiries.
A few weeks, months at the most.
Okay. Secondly, and I love the clarity of your presentation. You note that Part 18 of the Income Tax Act seems to require reporting on all U.S. reportable accounts unless the financial institution specifically designates an account to not be a U.S. reportable account. So there are financial institutions like the Lehman Brothers and others I could mention that may not have been exactly clear on how they conducted their business. So in this case, they don't forward the $50,000 or under accounts. They just say, well, this isn't reportable. So how would we ensure that a zero wasn't accidentally left off an account so that it could escape the scrutiny of the process? So I guess my direct question is, and it goes back to seems to require, why is it that the Income Tax Act would be so gray and unclear in its wording? One would presume that a lot of very smart people work on these things and they review it and they say, well, that someone should be able to see that there's a soft area in this reporting. So is it a recommendation that you would have is that we review and revise these matters to ensure clarity?
From a privacy perspective, there's no question that clarity would be extremely desirable here. If I can speculate on how we got to where we are, I would go back to the fact that the purpose of the agreement is to avoid tax evasion, and it may be that tax evasion will occur for accounts under $50,000. That's possible. So an agreement was negotiated between Canada and the U.S., and the sum total of the agreement and the Income Tax Act is unclear as to its effect. From a privacy perspective, that's highly undesirable because citizens do not know if they have accounts totaling less than $50,000, whether their personal information will be transferred or not to the CRA and ultimately to the IRS. From that perspective, clarity would be extremely desirable.
Thank you. It baffles me that we have so many resources within the government, and yet we constantly have to review. That's what we're doing here to achieve a better outcome. We hear from other jurisdictions who seem to have solved some of these problems. But I have to go back to the fact that just simply having another third party determine whether something is reportable or not, especially in view of so many of the financial scandals that have occurred around the world and so on, that it should be a simple matter. You may not need to answer this, but wouldn't it seem to you to be a simple matter to review the information and apply the correct remedies in terms of the wording so that we don't have to sit here and have these discussions at this level?
I don't have anything more to say.
Okay, thanks.
There's still 2.5 minutes. Mr. Saini.
Mr. Terry, just a quick question for you. I think so far this morning we've concentrated on individual personal accounts, but FATCA also includes commercial accounts for commercial enterprises. In your opinion, because that information is also privy to the agreement, in your estimation, do you feel that sending commercial information would be secure in the United States, and do you think that's the proper route, or should there be some other provision made for those accounts that are business accounts or commercial accounts?
I'm afraid that goes beyond the scope of my jurisdiction, right? Because commercial information is not information about individuals, which is the jurisdiction I have to look at the personal information of individuals in Canada.
In your opinion?
Well, obviously, there should be rules to ensure the safety of the information, whether it's commercial or personal information, yes.
Mr. Lightbound?
Just a quick question. I asked the minister earlier her assessment of the risk that Canadians who are not in any way, shape, or form linked to the U.S., who are not U.S. citizens, to be captured within that agreement. What's your assessment of it?
I think that's a tax policy question at the end of the day. Certainly from a privacy perspective, the fact that information is shared with the U.S. Is an exception to the rule, but the exception to the rule is justified by the desirability of avoiding tax evasion. So in terms of privacy, what I expect is that the objective be clear and legitimate. Here, tax evasion, it's legitimate. And how do you define the information that will be shared with the U.S. for that purpose? A certain choice was made. You've heard from the minister and officials on the fact that there was some negotiation with the Americans on what information would not be sent to the U.S. Government, despite the general objective. I note that according to the rules and the compromise reached, there are people whose link to the United States is, I would say, tenuous. People who are dual citizens, citizens of Canada and citizens of the U.S., and their U.S. citizenship may be due to their parents. They may never have worked in the U.S. So you can imagine a number of circumstances where the link of a U.S. citizen subject to this reporting requirement is tenuous. From a privacy perspective, once the agreement is reached, it's all right for the information to be shared with the U.S. Would it be desirable that a different agreement have been reached? Probably, but this is the agreement we have.
Thank you very much. We've gone up to onwards of 8 minutes there at that round. We now move to the 5-minute rounds, and Mr. Genereux, and if we can get through these, we've only got about 15 minutes left. If we can get through these relatively quickly, we can make sure that every party has an opportunity to ask a question.
I guess that's my first question to you, Mr. Chair. I'm hoping that we're quickly encroaching our time towards the end of the committee. Last committee meeting, we went right to the end, hoping that we still have some time at the end. Is that the plan?
The clerk has asked me for a few minutes at the end to get some motions from the committee. There is some committee business that we have to do. So I suggest if we have useful questions, we ask them. If we don't have useful questions, then we wrap it up as quickly as possible. So I'll leave it up to your discretion whether the questions are useful.
All right. Very useful questions, Mr. Chair. And I honestly just have a quick question. Just to clarify, it's September 30th, 2016 is the next transfer of records prior to or I guess that is the next transfer of records between the IRS and the CRA. Where were some of the concerns that are raised here are that a number of Canadians whose banking records were transferred were not notified. Is that possible at all between now and 2016? Do you see it as we're able to notify these Canadians, or is it within the current legislation? There's not a chance that they'll be notified.
I would distinguish between two stages to this information sharing. So normally, in terms of privacy, the information that a government institution receives should be directly from the individual concerned. Here, there is an intermediary, being the financial institution, but that is provided for under the arrangement and the agreement. So although an exception to the general rule, it is an exception that is authorized by law. So that's, should the information on funds owned by a U.S. person be collected by somebody other than a U.S. person, at law, the answer is yes, it can be collected from a financial institution. The question that was asked earlier this morning is, so assuming this regime, should the CRA inform the individuals in question that their information has been shared to the IRS? And I think there's no reason why not. What we heard is that under access to information provisions, that if somebody makes an access request, he or she will be entitled to that information. And that is absolutely true. So if that's true, then why not provide for a mechanism that provides for more systematic information being given to individuals?
Mr. Kelly, do you have anything? There's a little bit of time left.
Keep it moving.
I'm going to keep it moving then. We'll go back to the Liberals. Is there anybody here who has any questions? No, we're good. Is there anybody from the NDP that has any questions? Yes. Okay, Mr. Dussault.
I would like to come back to the question of disclosure, automatic disclosure. The only answer we had from the minister and from the officials was that citizens ought already to be aware of this because the banks will inform them, and that if they want more information, then they can refer to the questions on an answer section on a website. And if they want to, they can also write directly to us and get the information. obviously, I think it's absolutely legitimate they can access their personal information, their personal file. Now, do you think it would be possible to have this done automatically? Would it be possible to modify the framework in such a way so as the citizen would automatically be told that the information has been shared? And obviously it's particularly important when the information has been shared with another government, a foreign government. Do you think that's something that's realistic here? We're talking about 150,000 files that are an issue. Perhaps in September it might be 200,000 files, I'm not sure. So do you think it would be realistic to have people informed automatically? Answer. Well, at the moment, it's a matter of discretion. The CRA simply have to keep people informed in general by their website, and then they respond to specific requests that they get. So they certainly meet the minimal legal requirements. Would it be possible to do what you suggest? It would certainly involve a certain effort, yes. But we know that the government want to improve and facilitate access to information. So it seems to me that what you're suggesting would certainly fit in with that general idea. From a technical standpoint, you'd have to speak with the CRA. I imagine there would be an electronic means that would allow this to be done in a relatively straightforward fashion. Once the information has been shared, it should be quite straightforward to also inform the concerned person, but I would really have to have a closer look at it. Perhaps you could give us a written submission on the protection of Canadians in the US. We have heard about breaches in the US, and we want to know if Canadians have been affected by this and what the process would be, or what recourse Canadians would have if their files had been in any way compromised. Answer, yes, that's absolutely correct. Is there any time?
Sir, are concerned. I'm just going to ask one point of clarification from the Commissioner. Commissioner, you said that because of the discrepancy in the $50,000 that you said there was a concern that there might be over-reporting, but that same discrepancy might also result in under-reporting. Would you not agree?
The fact of the matter is that the rule is unclear, and that leads to uncertainty as to whether the information should be disclosed or not. I think this is undesirable. Right. Yes, perhaps it could lead to under-reporting in the sense that if the threshold did not exist, all financial institutions would be reportable. So you're right from that perspective, but still, Canada negotiated an agreement whereby this threshold was adopted, and I'm suggesting that we should follow through and clarify and ensure that threshold, that the information under 50,000 is not shared.
Certainly not going to dispute that with you, but there could be a better case scenario, not always the worst case scenario in certain circumstances. But either way, Mr. Commissioner, we thank you very much for your time here today and clarifying this very, very important issue. I know that as an MP previously, my office was inundated with many concerns. I was surprised to find out how many U.S. citizens I had living and working in my riding. Some people who had never even worked, as you aptly pointed out, for 1 minute in the United States. Were getting tax assessments, and it caused a lot of confusion, and there was a lot of frustration on their part, and I'm glad that we have some more clarification today at this committee, and I thank you for your time, sir. Colleagues, that ends the part dealing with the motions that was discussed that brought about this one-day study. I need a couple of motions to be approved in order for us to continue on with our studies to the access to information and privacy legislation. So I need somebody to move that a proposed budget in the amount of $22,500 for the study of the Access to Information Act be adopted. Could I have somebody move that, please? Moved by Mr. Boulouris. Any discussion? All in favor? Adopted. And in the same vein with the Privacy Act study, that a proposed budget in the amount of $22,500 for the study of the Privacy Act be adopted. Could I have somebody move that motion, please? Mr. Patina. Any discussion? All in favor? Carried. Thank you very much. I appreciate that, colleagues. I think that takes us to the end of our work for today. I'll just simply advise Mr. Smith.
Yeah, so as we know from the President of the Treasury Board and our previous discussion of the ATI Act, that changes are seemingly going to be made in the fall with respect to some items that were in the mandate letter, that were in our election platform, and that there will be a broader review of the Act going forward. I would suggest, so that we have a greater impact at this committee, that we aim to, at the very least, issue an interim report on the ATI Act by the end of this sitting in June. And I would propose that we stand down any further studies and focus completely on the ATI Act so that we can get something out the door, which may then be of use to the President of the Treasury Board when he goes to make changes in the fall.
So, Mr. Erskine-Smith, I take it that you are proposing a change in our current work study plan, or our work plan involving both studies. And did I hear you move a motion?
I will formally move that this committee study only the Access to Information Act going forward, that we issue a report, be it an interim report or a final report. We can make a determination at a later date, but that we issue a report in June to assist the President of the Treasury Board in his amendments to the Access to Information Act in the fall. And I would further move that the subcommittee meet next week to establish a work plan and amend the current work plan to get that done.
But if we're just so I'm clear, if you're moving a motion to change the studies, the work plan now, at the same time you're suggesting that the subcommittee meet to do the same thing.
To establish a work plan and come back to this committee with a fulsome work plan for the end of June.
So your motion is then to instruct the subcommittee to meet at its earliest convenience, to revamp the work plan and then report back to this committee and adopt it. We're not going to be able to do that before Thursday of next week, I don't think, which is a slated day according to our already motions to do this. So my advice to the committee is, we have a few minutes here. Maybe we don't need to meet as a subcommittee. If
I'm fine with that.
Let me just ask the question, is there general consensus at the table to do this, Mr. Généreux?
Yeah, I guess it's. I'm glad you guys are today on page with that. That it seems to have scooped us the budget there. However, I think with where we're going, though, we do have the President of the Treasury Board coming before us. I personally would like to, before we go down that road, would like to hear at least from him. We have invited him. He's planning to come. If at that point we look and we see that, okay, yes, he's open and to our feedback, right? I'm not, I guess, entirely convinced that he is at this point. If that's the case, if he is, then at that point I think we unanimously support focusing entirely on how we could do to help him going forward.
So what I'm hearing, Mr. Erskine-Smith, is that there's support for either a friendly amendment to your motion or support for the motion where the subcommittee would meet and review this with some folks at the table wanting to first hear from the Treasury Board President before we make a determination. So we've got general consensus, but some technical differences. Mr. Boulris?
Même si je salue.
I understand what my colleague's saying about the importance of spending time on the ATI. In the NDP, we feel that we shouldn't take flexibility away from the committee. I think the committee ought to maintain its flexibility to decide how it wants to work over the next few weeks. We don't want to get tied in.
We're proposing is that until June, instead of having the Thursdays dedicated to the Privacy Act, that we study the Privacy Act next session when we return in September. So instead, we just allocate our time to ATI, which could be more useful to the government to have recommendations in place for to have an interim report at least for the September return. So I don't think we're changing a whole lot here, or just focusing on ATI so that perhaps we can get something done that's going to be useful and inform the government and the House as it moves forward.
So, just for the edification of members of the committee, I have the schedule before me. Before we were going to the end of June, we will likely meet 16 more times, providing we sit till the end of the session, which means that we have 8 potential more meetings with the access to information and 8 potential more meetings with the privacy, presuming that, and the committee has given me great flexibility. Sometimes we don't get the right witnesses and we move things around. We still have estimates to do as well, and I propose that we do the estimates in the week after we come back from the next break week. So what I would propose, we have to. I think we should do that. I would propose on one of the days, the Tuesday, we have 2 of the commissioners come in and we'll go through the estimates with those 2 commissioners. And on the Thursday, we could bring the other 2 commissioners in and go through the estimates with those commissioners. Is everybody okay with that? They're booked for the 3rd and the 10th. Those are both. Those actually both happen to be Tuesdays.
Just to be sure, because I look at the 19th and the 21st of April, and we're still working on having witnesses for those dates.
Yeah, the 19th we have. Sorry, you're right, Mr. Lightbound. We have witnesses coming for the Access to Information Act on the Tuesday. We do not yet actually have any more witnesses for the Privacy Act on the Thursday. So. The motion would be easy to adopt because we wouldn't have to adjust an existing work schedule because we wouldn't have to cancel on anybody.
Better. Okay.
So other than we do have the Privacy Commissioner coming back, but I mean that's understandable. So, Mr. General?
Yeah, I think, and not trying to be difficult here by any means. I feel that if we go and we do adopt the motion now, we lose that flexibility once say for example the president of the Treasury Board comes in and he gives us the sense that he's going full steam ahead with this, and we're not comfortable that our opinion's going to be heard. Then at that point, I would think it would be more beneficial to us to move on to the Privacy Act versus staying on with the Information Commission Act. So what this kind of does, like it's only one Thursday really here that we're debating. So I guess from our side, you're saying it's one Thursday because it's only one Thursday we're not looking at the Privacy Act, whereas from our side we're saying that that's one Thursday that we're giving up the flexibility for the rest of this session that we're not going to look at the Privacy Act at all. And I guess just want to keep that flexibility open on our side of the table.
Well, by my records, we're giving up Thursday the 21st, Thursday the 12th, Thursday the 19th, Thursday the 2nd, 9th, 16th, and 23rd of June. And
between now and when the minister
comes, yes, there is only that part's true. Sorry, I'm trying to do 4 things at once here, colleagues. Bear with me. The other thing that I'll advise you is if we're going to do this, we need to provide time and instructions to our analysts so that they can prepare an interim report. If we were to reroute or reschedule the workload, I'd suggest to you that we probably, if we met until, say, the 7th or 9th, we would probably exhaust our witness list anyway, and we would be looking at a final report. We'd probably be much closer to a final report than an interim report. That's my personal opinion. I don't know that that's going to be, in fact, the case.
Well, that's why I say I would aim for a final report, but if in a determination at the time we say it's an interim report, so we provide something to the minister, so be it. But I think the goal would be to have a fulsome report.
So we have a motion on the floor. We're running out of time, colleagues. I don't want to drop the gavel and end the meeting. Do you want to vote on it, or should we meet as a subcommittee and come back with a proposal?
I think we should vote on it now, given the short time and given we got to get going on this.
So just so we clear what we're voting on an actual motion to change the work schedule, not to meet as a subcommittee. And the motion is that we suspend the study of the Privacy Act review, and we dedicate all future meetings until the end of June to the Information Act review. Are we clear on what we're voting on? Any further discussion? Okay, I'll call the question. All in favor of the motion? All opposed? Motion is carried. Colleagues, we have to go. I will look forward to seeing you